Thank you, Mr. Chairman, members of the committee. I appreciate this opportunity to present to you today. My name is Kent Nelson. I have been the General Counsel at the University of Idaho since 2006, and I'm here today to present on behalf of my client to address concerns over Senate Bill 1254. They say there's three arguments that a lawyer always does: the one he writes, the one he gives, and the one he thinks about in the car on the way back. I've already been listening, and some of the stuff that I prepared has already been addressed, so out of deference to people and their time, I may do a little skipping over, but I will deliver my written testimony to you. First, on behalf of the Faculty Senate of the University of Idaho, which is the representative body of our faculty, which also contains representation from students and staff, I will note for you that the Senate passed a resolution unanimously with 2 abstentions rejecting Senate Bill 1254 and supporting the existing policies allowing local control for decision-making with regard to safety policies at the University of Idaho. A copy of that resolution is with my testimony. I also want to reiterate, and I won't go through the policies, but the enforcement of the weapons ban policy that the university has here does not result in criminal liability for law-abiding citizens. It results in an invitation to leave our campus if they have a gun and are displaying it or we know about it, but they are peaceful and without a threat. We invite them to leave, and if they leave, we are fine and they are fine. So law-abiding citizens are not at risk of a criminal matter if they violate our policy with respect to weapons on campus. Our policy with respect to weapons on campus is quite clear in that regard. We think this bill is bad policy, and there's some challenges to the drafting. The policy contravenes the current policies of every public institution, or the bill contravenes the policies of every public institution of the state, removing local control, recognizing that the Board of Education and Regents and every administrator object to the policy. Most importantly, the proposed law will introduce weapons onto campus without the ability of the institutions to readily determine whether those weapons are there properly or not. Under our current policy, it's quite simple. If a weapon is there, we intervene. Under the proposed law, we will have students with enhanced licenses who are indistinguishable from students who do not have a license. I've seen nothing in statute or in the proposed legislation that would require those license holders to reveal themselves or their permits to us. If someone tells us they're a permit holder, are we simply required to trust them? If so, how do we know we're trusting a permit holder or a liar? In that context, then, how do we regulate those weapons that appear on our campus, and how does this enhance safety on our campus? The next concern is with the language of the bill itself. This bill does allow open carry and display throughout the campus, including classrooms. A concealed carry permit is simply permission to conceal, but it is not a requirement to do so. There are no rules that I've been able to find that prohibit the holder of a concealed weapons permit from openly displaying the weapon. The statement that the bill will bar weapons from student housing and sporting events is very questionable in my mind. A close reading of the language reveals that it only addresses concealed carry in those areas. The language of proposed section 2A of the bill states that the permit holders shall not carry a concealed weapon into a dormitory or entertainment facility. It doesn't say that they shall not openly carry their weapon into a dormitory or facility. And because there's no rules that a permit holder actively conceal their weapon, I don't see where this bill prohibits someone from openly carrying their weapon if they in fact have one of these permits. Second, and this takes some reading, but it's stated that this bill will not allow someone under 21 to get a permit that allows concealed carry on campus. However, if you look at the bill, you will not see the words age 21 and up. Instead, you have to look at Code Section 183302K, which governs the enhanced concealed carry permit. And in that language, you also don't see age 21 and up, but instead you are referenced to whether an applicant is, quote, disqualified under any of the criteria listed in Section 183302(1)A through N. So, if you go to 183302, what you will find is that the language, limits the concealed carry permit to someone who is disqualified. And then if you go to 183302, what you find is subsection 1L. And subsection 1L appears to limit concealed carry permits to those who are 21 years and older, but if you continue to read the section, you find subsection 11. And under subsection 11 reads, the sheriff of a county may issue a license to carry a concealed weapon to those individuals between the ages of 18 and 21 years who, in the judgment of the sheriff, warrant the issuance of a license to carry a concealed weapon. So how can you say that that person is disqualified when they in fact have a concealed weapons permit? In that regard, then we would potentially have 18-year-olds who would qualify for these permits. Third, it's unclear how this proposed law will affect our relationship with employees or contractors in critical areas such as those associated with camp and safety. As was discussed, we have security officers and they are not armed. They do engage students in public in situations that can become stressful, and they are trained in that regard. Yet under the proposed law, employees would be prohibited, we would be prohibited from having a policy that prohibits our employees from electing to carry themselves. So if this law passes, by de facto, we will have no choice but to train and presume that people such as security guards will arm themselves, and so we'll have to deal with them as though they will be and will need to be armed. I don't think that necessarily enhances safety on our campus, and that certainly is going to be an expense. Lastly, if you like a little irony, if you look at the immunity language under the bill in conjunction with this attempt to bar weapons in the dormitories and entertainment venues, the institutions are rewarded with immunity to the full extent that they choose not to regulate otherwise lawful possession of weapons. An institution that chooses to abdicate any control receives full immunity. This means weapons on campus anywhere otherwise not barred by law. In Idaho, you're not barred from possessing a handgun at any age. Idaho Code Section 183302G5 allows a minor under the age of 18 to possess a handgun with the parent's consent, so long as that minor is also on real property with the permission of the owner. That statute does not say that the owner has to give permission for the possession of the weapon, only that the minor be on the property with the permission of the owner. We have families who visit our students in our dormitories all the time. They have our permission. Then the logical extension of this is that we could have families to authorize their children to carry handguns, and that would qualify for carry in our dormitories if we abdicate any control over carry. So here's the irony. The irony is we could have an 18-year-old in our dormitory carrying a weapon because their parents allow them, but we could not have the very people who the proponents say are the ones who will make our campuses safer, which are the holders of these concealed weapons, enhanced concealed weapons licenses or retired law enforcement, because the statute says they can't have concealed carry in the dormitories, even no matter what the universities do. So for all of the reasons that have already been stated on the policy side and will be stated, we think this is bad policy, and we think there's some real drafting challenges as well. So thank you.
Are there questions? Hearing none, thank you.